So, I'm Joanne Richards, and I'm the League of Women Voters of the Austin Area VP for Advocacy and Education. And the Advocacy and Education Committee thought that it would be apropos for us to have a presentation on voter suppression in the state of Texas, considering that we are now entering into an election cycle. And as you will see, eventually we will be into a census-taking cycle where all kinds of new and interesting things will likely happen. So let me start the presentation, though. I can't thank Kelly and Grace enough for helping me put this presentation together. Texas has a long history of voter suppression. Come take this journey with me as we explore the many ways that Texas has tried to suppress voting. I have to go to see why this is not forwarding. There we go. So we begin with a poll tax. The poll tax began in 1869 with a poll tax of $1. $1 in 1869 is worth about $23.83 today. The poll tax in 1902 was increased to $1.50 and again increased to $1.75. It's interesting that the grandfather laws exempted poor whites from that poll tax. The poll tax was prohibited in 1964 with the passage of the 24th Amendment. It prohibited both poll taxes and literacy tests in federal elections. In 1903, there was a law passed in Texas called the Terrell Election Law. It established a direct primary nominee system. It allowed for political parties to restrict their membership, thus barring certain people from participating, Blacks and Hispanics being two. This effectively created what we would now call a whites-only primary. There were several court challenges to this, to the Terrell law. The first two, Nixon v. Verndon and Nixon v. Condon, these two cases declared that the whites-only primary was unconstitutional. The third case, Grover v. Townsend, determined that because the Democratic Party was a private organization, it could limit membership. It wasn't until 1944 that the U.S. Supreme Court finally and decisively prohibited whites-only party primaries in a court case called Smith v. Albright. So the demise of poll taxes and literary tests took a number of years and a number of actions. In 1964, we talked about the fact that the 24th Amendment prohibited the poll tax in federal elections, but Texas continued to require them for state and local contests. In 1966, the United States Supreme Court ruled in Harper v. Virginia that poll taxes in state elections violated the Equal Protection Clause of the 14th Amendment. So, as a result, in 1966, following Harper v. Virginia ruling, the Texas legislature repealed the requirement, ending decades of the poll tax being used to restrict voting. It didn't take long to find new ways of suppressing the minority vote. This begins an era in earnest, the use of redistricting and district population size to suppress the vote of certain populations. And so here we begin in 1973 with a case called White v. Register. And in 1971, the legislature went through the redistricting process. It voluntarily split Harris County into single member state house districts, but 11 other counties had huge multi-member districts. The new house maps were challenged in court for several reasons. So it was thought that single member districts were more favorable to a more diverse population, and that at large districts diluted African American and Hispanic populations from voting. In 1973, again, White and Register, the Supreme Court struck down the at-large multi-member districts, both in Dallas County and in Bexar County, calling them tools to diminish the voting power of minorities in those counties. Dallas County drowned out the Black vote. Bexar County drowned out the Mexican American vote. And Dallas and Bexar counties moved from at-large to single-member districts soon afterwards. In 1973 as well, in White v. Weiser, there was a different challenge. The U.S. Supreme Court struck down what was then SB 1. You'll see SB 1 coming up over and over, but it's different years and therefore different legislation. But SB 1 from 1973, the new Texas congressional redistricting map, because it violated Articles 1, Section 2 of the equal population requirements. And so Article 1, Section 2 strictly requires that congressional district populations be as mathematically equal as reasonably possible. Population variances among those districts are only constitutionally permissible if they are shown to be unavoidable despite a good faith effort to achieve absolute equality or are otherwise justified by the state. So in drawing maps, if you have one district whose population is much larger than another, therefore diluting its population, it's considered unconstitutional. In 1975, the Voting Rights Act was amended to reauthorize certain provisions that were to expire by 1970. Congress expanded the act's scope to protect language minorities from voting discrimination. If the jurisdiction had a single language minority group that constituted more than 5% of the jurisdiction's voting age citizens, they had to be accommodated. Congress also defined language minority to include persons who are American Indian, Asian American, Alaskan Natives, or of Spanish heritage. Texas now provides election and voter materials in Spanish because our population of Hispanics here is more than 5%, so it's required by law. 1975 to 1991. At-large districts are being examined more fully. At-large versus single-member districts and city council elections. There were 3 cases. Each determined that at-large city council election systems violated the Voting Rights Act sections 2 and 5 by denying Latino and Black voters an equal opportunity to elect candidates of their choice. There were two um, court cases out of Dallas. There was one out of Baytown. The Dallas case said that it diluted the black vote. The Baytown case um, suggested that it diluted the Latin and black vote. And again, another Dallas case diluted the minority vote, each taking place in a slightly different year. Um, so this concept of at-large city council elections took place over decades. From the 1990s to 2006, now we get into the area of racial gerrymandering. And there are two cases of importance here. One is Bush v. Vera in 1996, where the U.S. Supreme Court declared that three Texas congressional districts, two in Harris County and one in Dallas County, were unconstitutionally gerrymandered under the 14th Amendment because race was a prominent factor in drawing these majority-minority district lines. These particular districts happened to favor Black and Latino votes, but that was equally declared unconstitutional. In Lulac v. Perry in 2006, and many of you will recognize this one, the Supreme Court declared that the redrawing of District 23 in Southwest Texas by the 2003 mid-decade congressional redrawing of districts that were championed by Tom DeLay intentionally reduced the ability of Latino voters to elect their preferred candidate, diluting the Latino vote. This is not the only case where mid-decade congressional maps will come into play in our history through this. So Austin faced a problem because Austin had an at-large city council. So Austin faced the challenge to its at-large city council elections. In 2012, Austin voted to change the makeup of our city council from all at-large city council to a 10-1 single-member district. So there will be 10 individual districts, each being represented by a different city council person, and then the mayor would represent the whole city. The prior unofficial agreement to seat one Hispanic and one Black city council member was not going to hold up in court any longer. And so it was brought to a vote. A number of people went out to get signatures to force a vote. It was on our ballot in 2012, and we voted in favor of it. So now we get to yet a new set of voter suppression attempts, successful attempts, if you will. And 2011 began the voter ID law. I'm going to call it the voter ID law because it's too much of a mouthful to say voter ID laws. So this was SB 14. Proponents argued that it reduces electoral fraud and increases voter confidence. Opponents say that such laws are partisan and designed to making voting harder for low-income people, people of color, younger voters to vote. People in these groups tend to vote Democrat. So what kind of, I think most of you are familiar with those photo IDs that are permissible, and they are typically ones that are sanctioned by the state or the federal government. Not university IDs, not employee IDs, but those that are sanctioned by the government. SB 14 was successfully challenged. The Fifth Circuit Court of Appeals declared that SB 14 violated the Voting Rights Act sections 2 and 5, and that remedies were going to be required. And we'll come to that in a few minutes. But this is 2011, and the remedies don't take place until 2018, I believe. So we have a new, really contentious situation. And this was in 2013, Shelby v. Holder. Section 5 of the Voting Rights Act required states and localities with a history of racially discriminating voter practices were required to get approval of any voting changes by the federal government. Section 4B included the coverage formula to determine whether a state met the need for preclearance. When 4B was declared unconstitutional by the U.S. Supreme Court in Shelby v. Holder, it basically nullified Section 5 because you no longer had a viable formula. So Section 5, therefore, was not possible. This was all called preclearance. Texas was subject to preclearance, but in fact, now preclearance is no longer required. So now we move to 2018, where the voter ID law of SB 14 was remedied. If a voter does not have a voter ID, photo voter ID, the voter may vote if they complete a reasonable impediment declaration and can provide one of the following. And these are copies of documents that demonstrate or can show where they live. And because it shows where they live, it shows it will match up with the voter files so that the person can be identified as a legitimate voter. All of these documents were documents before SB 14 were accepted before SB 14 was passed. So, and the reason I know that is because I was an election judge then, and I remember seeing all those. So it's not unusual. So it was amended. Now we come to something new. Yet again, another way of voter suppression. Voter rolls need to be purged. They need to be cleaned up on a regular basis to eliminate those who have moved, those who have died, or for legitimate reasons may no longer be eligible to vote. LULAC filed a suit against the Secretary of State. The Secretary of State at that time was David Whitley. And the suit claimed that the voter purge was flawed. The Secretary of State asked for the removal of illegal non-citizen voters from the voter rolls. However, the list he used was stale and it was outdated. The targeted individuals turned out to be newly naturalized citizens. So they became citizens between the purge and the election itself. So in fact, they were legitimate. Many of you may remember that David Whitley stepped down soon after that debacle. But we do know that we do need to have viable voter roll purges from time to time. Now we get into SB 1 restrictions. SB 1 passed by the 87th legislature took aim at get out the vote efforts implemented because of COVID. And many of these were in Harris County and then adopted by other counties. The plaintiffs argued that SB 1 violated the Voting Rights Act and the Americans with Disability Act because it limited voters with limited English proficiency or disabled voters the ability to choose their assisters when voting. So here are the restrictions. The first one is restricting the aid in voters, right, who needed help completing or returning their ballots. But it went on. It enhanced the role of partisan poll watchers. It enabled a ban on drive-through voting. It restricted early voting hours, which imposed a ban on 24-hour voting. It criminalized many voter outreach efforts. It increased mail ballot signature matching rules, and a whole lot more, all in violation of the First, 14th, and 15th Amendments and the Voting Rights Act, Section 2, and the Americans with Disability Act by imposing undue burdens on the right to vote, particularly for voters of color, voters of disability, and uh, elderly voters as well. The next two slides demonstrate the long road of litigation. There are two important 2020 cases that have come before the court. Lupe v. Abbott and Brooks as well. The redistricting cases of Lupe and Brooks claimed dilution of minority vote, creating a racially gerrymandered district. After much litigation over SB1, a decision came down in March of 2020. So remember that this started in 2021. Okay. So a decision came down in March of 2025, following a 6-week trial in a San Antonio U.S. District Court, concluding that the state had failed to make reasonable modifications to avoid discrimination and, quote, as a result, voters with disabilities have experienced multiple mail ballot rejections and experienced humiliation, the loss of their privacy, and physical pain while voting. The decision was appealed to the U.S. Fifth Circuit Court of Appeals on November 21st, 2025. It was then appealed to the U.S. Supreme Court in January of 2026, and the Supreme Court has not acted. So it's almost 5 years and we still don't have an answer. In Brooks v. Abbott, the complaint centered around two aspects of the 2021 census redistricting plan after the 2020 census. The first, reconfiguration of Texas Senate 10 in North Texas. The plan purposefully broke apart a district which had formerly been an effective crossover district for minority voters into a racially gerrymandered district where their vote was diluted. It also split up Tarrant County, resulting in the dilution of African American and Latino voting strength. Now we come to 2025, where we have another midterm redistricting plan. Greg Abbott signed redistricting bill HB4. So repeating the 2006 effort by Tom DeLay, after much litigation, a 3-judge panel ruled the redrawn congressional map was unconstitutional, requiring the use of the 2021 maps in the 2026 midterm elections. Guess where we are? We're in the primary right now, right? Texas has appealed to the Supreme Court, asking the court to stay the decision. The Supreme Court granted that stay, which means that the 2026 midterm election that we were in now are under the new maps, not the old maps. Can it get any worse? Well, from the League of Women Voters point of view, yes, right? The U.S. Citizen and Immigration Services issued new policy guidelines barring nonpartisan organizations like the League from providing voter registration services at naturalization ceremonies, making it harder for new citizens to register to vote, silencing their voices. This attempt to shut down the honorable and sacred work of registering new voters is unacceptable. It has also become quite challenging to find where and when these naturalization ceremonies are taking place. So there's a double whammy. So what should we be watching for in the future? Well, the 2030 census is going to take place before we know it. Before a census takes place, there is a testing of the methods that will be used for the subsequent census taking. It has already begun for the 2030 census. Unfortunately, the field testing was reduced from 6 cities to 2 sites. One is Huntsville, Alabama. The other is Spartanville, South Carolina. Population of Huntsville is 249,000. The population of Spartanburg is only 39,600. The complaint is that those cities are too small to get an accurate reflection of whether the field testing is working. The second piece is it will examine new methods for counting the population, including the U.S. postal workers for field tasks. U.S. postal workers, that's not their responsibility. Their responsibility is to deliver mail. The census determines our population. The population determines representation. So they are equally important, and the census is critical. What more should we be watching for? Well, after the census is completed, redistricting will begin. Watch for vote dilution, packing, cracking, and the return of at-large districts, which will dilute the minority vote, all having an impact on Blacks and Latino voters. Watch for an increase in photo voter ID requirements and for ballot by mail rules. Watch for an increase in limits to assisting voters. All of these are impediments to voting for vulnerable groups, whether they are disability groups, whether they are minority voters, whether they are voters who are older and have difficulty meeting the requirements. So those are all of the remarks I wanted to make.